Okay, Maddie, take it away and thank you.
All right. Good afternoon, everyone. Thanks for joining us. I'm Maddie Bell. Like Marcia said, I'm an associate attorney at Cavitch, and I'm joined with a partner here at Cavitch, Max Dane. We're back again for the second series in this three-part series, and today we're talking about disability discrimination. Disability discrimination has some unique nuances that we want to discuss because we see every day employers run afoul of some of the pretty specific requirements of the ADA and Ohio law. But first, I'm going to talk about some of the risks of disability discrimination issues. Now, if you joined us for our first part series, the sexual harassment segment, a lot of this is going to sound repetitive. But for those of you that weren't on that webinar, I want to just touch briefly on these items. So first, one of the biggest risks of disability discrimination issues in the workplace is a loss of talent. So folks dealing with disabilities still have a lot of talent to offer, and there are sometimes maybe some biases, some misinformation that occurs on what an individual with a disability can and cannot do. And they have a lot to offer. So if there are biases that are interfering with an employer's ability to recognize the talent that a disabled individual has, you could be missing out on a huge pool of talent. And I know that, part of manufacturing works benefits that they provide to you folks is retention of employees and, bringing employees to the greater Cleveland area and having them stay put in your companies. So this is an entirely talented pool of individuals that should be considered along with non-disabled individuals for roles at companies here in greater Cleveland. Similar to sexual harassment, there's obviously a huge risk to operations when there's disability discrimination issues at play in the workplace. And again, like the sexual harassment issues, culture is huge. The workplace right now is super competitive for employees. You want to have a culture at your company where employees like to come to work every day so that you can retain them. The risks to operation include disrupting working relationships. Obviously, anytime there's any type of tension in working relationships, productivity suffers. That is true with regard to those involved in the disability discrimination issues that are occurring. And that's true to just with regard to those involved in the kind of a gossip mill that occurs at a workplace. So you don't want that type of toxic work environment at your company. Another risk is the risk of litigation. So time costs, money costs, and reputational costs. The time cost, COVID has increased this a little bit, and this is true for the previous presentation that we put on as well, but you're going to be looking at roughly 2 years in litigation if litigation occurs. Max and I recently just settled a disability discrimination issue. That case was filed in 2019. So it's been on the docket for a minute. You're looking at a significant investment in time, and obviously that takes away from your employees being able to do their jobs. And money costs. Just in settlement, you could be looking at hundreds of thousands of dollars, and obviously that increases if you go to litigation, as well as defense costs. If you want Max and I to defend you, well, we don't work for free. No attorneys do. So there's definitely defense costs there. And reputational costs. So anytime you're on the public docket, it's not a good look for the company, especially with disability discrimination issues. Disability discrimination, when the laws were passed, it was a bipartisan effort. I think that generally in civilized society, we can agree that, discriminating against somebody because of something that they were born with is, or that has occurred throughout their life that has disabled them is just unacceptable. And you don't want to be a company on the docket that is being put in a negative public light for that type of discrimination.
Maddie, just, to jump in, it's kind of an overview in terms of how we counsel clients or how we approach this topic. Obviously, the first and best practice is to comply with the Americans with Disabilities Act and the Ohio similar statute. And generally, that embraces a view toward accommodating persons with disabilities. There's no question that we run into a lot of scenarios where you have people, you've got slackers and quacks and literally crazy people who have embraced the idea of, accommodations for their own purposes. And we deal with that and defend employers with respect to that. But the best practice remains a view toward accommodating people as is required under the ADA.
And I'm going to let Max continue a little bit and give you guys an overview of the laws that come into play with disability discrimination.
So our first point of reference is the Americans with Disabilities Act. The Americans with Disability Act goes back, I think, till 1990, and it was amended very substantially in 2008. And we don't have to go into the twists and turns of the 2008 amendments, except to say that in 2008, Congress directed courts to take a very expansive view toward what constitutes disability under the Act. And we'll talk a little bit about how to distinguish between conditions that do give rise to a disability and those that don't. But it's generally a safe bet that the complained of condition is or likely is a disability as protected by the Act. And Ohio has what we call a Cognate Act, a very similar act that governs discrimination in the workplace, and that's ORC 4112. And I have a note to myself that we revised, we meaning the state of Ohio, revised 4112 a few years ago. And one of the kind of salient revisions was that 4112 now carries the same statute of limitations that the Federal Americans with Disabilities Act carries, and that's 2 years. Again, we're not really here to talk lawsuit stuff, but I mean, it's always important to understand at what point a complaint is or is not actionable. Again, Maddie said it earlier, I'll say it again, the goal that we counsel employers toward, and I think is the appropriate goal to kind of keep in mind, is to accommodate individuals who are dealing with disabilities. I think this may be along, and it's a little bit of opinion, but this, along with women feeling more comfortable to come in and contribute and make a difference in the workplace, has vastly improved American productivity, American ingenuity, and generally American ability when it comes to operating our businesses. I really do believe that. It can be difficult, sometimes it can be even painful to comply with what feels like a complex regimen of federal and state requirements, but generally, for what it's worth, I'm all for it. Now, we have a title here, administrative process. That's because if someone wants to press a lawsuit with respect to the Americans with Disabilities Act or the state law, they have to first go to the Equal Employment Opportunities Commission or the Ohio Civil Rights Commission and make their complaint heard there first. That's a requirement before you can file a lawsuit. And at that point, we're dealing with, either resolving the matter there or coming to understand what the facts are. So maybe we'll jump into this later, Maddie, but we wanted to talk about, the difference between, at some point, what a disability is and what isn't a disability. So Maddie's going to talk about the definitions associated with disabilities. I guess I'm going to take the opportunity to sort of point out some conditions that aren't disabilities.
Sure.
And essentially, short-term harm, even if it's severe, that arises as a result of illness or injury, is probably not a disability as we think about it under Ohio law or federal law. Examples would be whiplash from an automobile accident. You break your foot. You're in severe pain from some kind of an event or even an illness that's going to resolve quickly. Those are generally not conditions that we contemplate within the Americans with Disabilities Act. Those are going to, the easiest distinction is that they're going to resolve in the short term, even though they may impose severe restrictions on the abilities of the afflicted person.
And I think that one good thing to point out that's a little bit timely here is I recently attended a webinar that discussed the effects of COVID as a disability. And the EEOC put out some guidance kind of directing that, you know, it's called long haul COVID. So, you know, somebody had COVID-19 and they are still experiencing some symptoms. I think that headache is one. I think that heart problems are one. So that's definitely an evolving topic and something to keep in mind if you have somebody coming to you that had COVID saying, you know, hey, I'm having heart issues because of COVID, and you know, just keeping in mind that the ADA may come into play there.
So a little more on the law. You know, we talked about some of this in our presentation a few weeks ago, and I think some folks who were with us then may be with us today. We don't have to go into a ton of depth. We talked in some detail about the legal process and what constitutes, well, what happens when somebody files a lawsuit. And we talked a little bit about process and cost and time, and the focus that that often takes away from the creative and fundamental business purpose. It can be lengthy, it can be expensive, and again, we talked in some detail about that. I don't think we have to go through that again today. When you do get sued, what the plaintiff is going to be looking for in terms of recovery is front pay, back pay, punitive damages where an employer is found to have acted in a real egregious or real lousy way. Generally, there are attorney's fees available to a plaintiff. That's an important thing to keep in mind. While you may be thinking in terms of, well, this person only made, say, $20 an hour, and they've got maybe a half a year in back pay by the time we get to some point of resolution, and it seems that they'd be able to get a job within the next year or so, and so there shouldn't be a ton of front pay. Well, don't forget the fact that the defendant, if the plaintiff is successful, is going to have to carry the freight on attorney's fees for a successful plaintiff. Somebody sues you, you got to pay their lawyer if they're successful. That's generally the case. It's particularly the case under federal law and in federal court. It's a little dicier for the plaintiff if they're in state court suing under ORC 4112, because at that point they've got to kind of demonstrate that the misconduct was particularly egregious, such that they might have a run at punitive damages. Plaintiffs will also be looking for reinstatement often, and they may be looking for equitable relief. Equitable relief means the court requiring the employer to do something. Generally, the court requiring the employer to, for instance, undergo disability sensitivity training, or somehow change the conditions which gave rise to this employee's complaints. And I don't know if, we do have emotional distress damages can be fairly weighty as well. We spend days in seminars on the nature and scope of damages. We don't have to do that today, but just to kind of provide an overview of potential outcomes, financial outcomes. And again, I stress the aggravation, the time, the focus, the distress of being involved in litigation, I think often outweighs the financial cost. We're in the business of keeping people out of court. If you go there, we win for you. But we're first and fundamentally in the business of keeping you away from that side of the issue.
Something else that's a little bit important to mention is, like the sexual harassment issues that we discussed last time, different states have different rules, different laws with regard to disability discrimination. So we're discussing, Ohio's revised code 4112 today. But for example, California has a very different discrimination statute that provides some more protections for employees, and also has some differences in the remedies available to that employee if they were to file a lawsuit. So if you have different operations in different states, and you're, sued in state court, what you can expect is a little bit different.
Well, I want to just jump on that too. If you have different operations in different states, if you have employees who are, say, doing sales from their home in Wyoming or Illinois or California, what you want to do, in my view, is write an employment contract in which we all agree that our employment relationship is going to be governed by the laws of the state of Ohio. Because with respect to Ohio, people may argue, is it business friendly, is it not, or taxes, this or that. I can tell you that Ohio discrimination laws are generally more employment friendly and rarely exceed the requirements of federal law, as opposed to other states. So generally, first of all, it's just smart, if you're located here, you want a lawsuit to happen here.
Right.
So you would identify Ohio as your venue state. And second of all, you would choose Ohio law as the law that would govern any dispute, or that would govern the employment relationship. And again, that's generally set forth in an employment contract. You can make those choices as an employer.
All right, so like Max mentioned, I'm going to go through, what is a disability as defined under the ADA. And there's kind of three buckets that a disability can fall into and still be actionable. So these are kind of like three different claims that a potential plaintiff could bring. The first is the more traditional, listen, this person has a physical or mental impairment that substantially limits one or more major life activities or one or more major bodily functions. And I'll go through what a major life activity is and what a major bodily function is. So that's kind of the more traditional, listen, this person has a disability that they're dealing with, and it's substantially limiting their ability to do one of these things. But to have an action under ADA or Ohio law, it's not even necessary for a person to be suffering from a disability at that time. The first way to have a claim where they don't have a current disability is having a record of such impairment. So let's say this person suffered from anxiety in the past. They have a record of having such anxiety. That is still going to be actionable if an employer is treating them differently because they used to have anxiety. The second way for somebody to have an action and not even be suffering from a disability is the employer perceives them as having such impairment, and that's called being regarded as having a disability. So this comes up often with folks that suffer from some sort of personality disorder, or the employer thinks that they suffer from a personality disorder or some kind of IQ issue, some sort of learning impairment. So maybe the employer is treating them differently because they think they have a disability when in fact they do not. So let's walk through some examples of major life activities. And this has been litigated, different cases have established these are major life activities. So caring for oneself, can this person dress themselves? Can they shower? Can they comb their hair? So performing, self-care. Performing manual tasks. Can this person drive? Can this person operate a machine? Can this person garden in their garden? Any type of manual labor, can this person do those tasks? And more traditional ones, seeing and hearing. Eating, a lot of times disorders can inhibit folks from being able to eat normally, or maybe they have to eat more frequently. Diabetes is one that comes up often, or hypoglycemia, low blood sugar issues comes up a lot, and eating is obviously involved in that. Can they sleep normally? Can they walk normally? Can they stand normally? Lifting is a huge one. I'm sure in your companies, folks have to be able to lift a certain amount of weight in specific positions. So lifting can become a big one, and bending as well. if you're lifting something, you generally have to be able to bend down to get it. Speaking and breathing are also some major life activities that we see quite often in litigation.
I was just going to say, and also interacting appropriately with others.
Yeah. So personality disorders, and we'll get into a couple of examples, but personality disorders are huge. They're often hard to peg, what is this person's diagnosis and how do we appropriately deal with it? Can we deal with it in this workplace? So that's a good point, Matt. So major bodily functions, it's along the same lines of major life activities. It's just a little bit more general. So having immune system deficiencies, having issues with normal cell growth, digestive issues, bladder and bowel issues, neurological and brain issues that you guys can read through. But it's basically, just any type of function that the body normally performs. If somebody has a disability in which they cannot perform this type of function, that's going to go towards the definition of the first more traditional disability. So let's go into a little bit of the two types of issues that can arise where individuals don't actually currently have a disability. So the first is a record of impairment. So this means that the individual, the employee, has a history or has been misclassified in the past as having a mental or physical impairment that substantially limits one or more major life activities. So this type of disability discrimination prohibition is geared towards helping people who have recovered from a previously disabling condition and who may remain vulnerable to fears and stereotypes that the employer has associated with that condition. And all the employee has to show is that at some point in the past, the employee had a disabling condition. Most typically, when we see a record of impairment, there are medical records that establish at one time this person had this diagnosis, but they no longer do anymore.
I think a good example is somebody who's struggled with some kind of a psychiatric condition.
Yep.
With medication, that condition is eased. The employer became aware of that condition in the past, and then going forward treats that person differently, as in a negative way.
Correct. And the second way that an individual can still have a disability discrimination issue and not even have a disability is when an employer regards an employee as disabled. So the individual has to just show that he or she was subject to an adverse employment action because of an actual or perceived impairment. And since 2008, this is one of the changes that was pretty significant that Max was talking about when the statute 88 was amended. Since 2008, the individual is not required to show that the impairment perceived by employer is substantially limiting a major life activity. So that's no longer a requirement. All the individual has to show is that the employer regarded them as having some sort of disability. And like Max mentioned before, the impairment can't be transitory and minor. So it's actually established and defined. Transitory is the actual or expected duration of the disability is 6 months or less. That's something to keep in mind. Like Max said, a broken foot because of a car accident is just not going to do it if it's going to be healed within 6 months or less. So when we first started, I mentioned that disability discrimination claims and issues that come up in the workplace are pretty unique. And one of the things that makes disability discrimination issues unique is employers are required to engage in something called the interactive process. And Max is going to go into what the interactive process is and what's required of you as an employer.
First, I won't just read what's on the screen, but I think that provides a really helpful guide. I just want to say, as a kind of a fundamental matter, the interactive process means, that's probably obvious, that the employer has an obligation to interact with the employee to determine the scope of a disability and to determine what, if anything, I can reasonably do to accommodate that disability. And it's one of those things where you don't want to, sometimes you have owners, managers, HR folks who get a little lawyerly about it and start saying, well, the employee didn't actually ask for an accommodation, so I didn't have any obligation to engage in kind of a process. And because their performance isn't up to snuff, we fired them. That can be a real issue. Actually, the employer does have an obligation to engage that process upon reasonable notice that this individual is suffering from some kind of a potential ADA issue. So obviously, if the employee asks for an accommodation or the employer notices an accommodation may be necessary, this person is consistently underperforming in a way that they hadn't. They're underperforming and exhibiting signs of something that's giving rise to this. That's something that the employer has an obligation to kind of proactively reach out and say, what's going on here, and to understand how the employer may be able to engage in a way that accommodates a potential discrimination. We've said it's a dialogue. The interactive process is dialogue between employee and employer, where the parties kind of determine what accommodation can be offered to allow the employee to succeed. At some point, I had a note to myself to stress, I'll do it here. The employer does not have an obligation to provide an accommodation of the employee's choosing. The employee may want to tell you what shifts they can work. The employee may want to tell you which store they want to work in. The employee may want to tell you what role they want to function in. The employee may have a lot of, and they may all be valid. And it may be that it makes sense in working with an employee and perhaps with a doctor or whatever, that's what you do. But the employer is not obligated to adopt the accommodation of the employee's choosing. What the employer is obligated to do is provide such reasonable accommodations that'll enable the employee to succeed in their work. So the employer may say that a reasonable obligation is, okay, I can change your shift from such and such to such and such, or I can provide you breaks as you need them to administer your medication or whatever the need for a break may be. But no, I'm not going to move you to a different store. We go on and on with examples, but those two salient points for me stand out. First of all, we do have an obligation to interact and to figure out how an employee can be reasonably accommodated. And second, we don't necessarily have to provide the accommodation of the employee's choice.
If I could just jump in really quick. The one thing that I will say, and this is an issue that Max and I just recently dealt with, reassigning an individual is a little bit sticky. That's the one kind of caveat that I would say with regard to what is a reasonable accommodation and what is an employer required to do. So reassignment, you're going to want to try to at least examine and look at whether you can accommodate the individual in their current position first. If there are issues with that, reassignment may come into play. But I think that it is a tough position to take as an employer if reassignment is the first thing that you suggest when there are other accommodations that could keep that person in their same position.
So to be clear, when we say reassignment, I think what Maddie's referring to is taking you from job A and moving you to job B, such that your work is different.
Correct.
That which you do is different. And I agree, that's generally an accommodation, kind of, I think, as we would say, of the last resort.
Correct.
It's a valid accommodation, and it may be all that you have.
Right.
But generally, we try to work through other kind of possibilities before you impose that.
And I think the last thing that I wanted to kind of talk about, so with the interactive process, seeing if you can accommodate that individual, well, what is the line for an employer where it becomes too big of a burden, an undue burden on you to make an accommodation? And Max is going to talk a little bit more about that, but one note of caution that I wanted, and I put it on the slide because Max and I deal with this quite often. We counsel different sizes of companies, and what's an undue burden for a mom and pop shop may not be for, some of our bigger clients. Walmart's not a current client, I wish, but Walmart, they're going to have a lot higher of a burden just because they do have the money to help out folks. They do have the ability to shift folks around. So what is an undue burden for a small company is not going to be for a larger company all the time.
By example, a billion-dollar manufacturing concern may be required to actually hire someone
Right.
to provide assistance to an employee in order for them to accomplish their work. That's not going to be imposed on a localized business that is grossing $11 million a year.
Right.
That view does come into consideration. So we're going to talk, I guess, about what constitutes essential job functions. And this is important because what we're talking about is a disability that the employer isn't required to sustain anybody's employment if they can't accomplish the essential job functions required either with or without some form of accommodation.
Right.
So if then we get into a lot of arguments over what is the essential job function. And so I think it's worth kind of taking a look at what we've written here, the essential fundamental job functions as opposed to marginal job functions. When we're saying, well, this is essential to this position, you're asking, well, what's fundamental? Is it basic to the position or is it not? And we'll provide a couple of illustrations that may help kind of make that point. So as Maddie put here, the question is, will removing the function change the position? By example, we represent a very substantial retailer, and they had an issue with a hearing impaired employee. And this retailer has multiple stores in a lot of locations, and the store manager felt like, look, I can't work with this individual. I don't have a shift form where this works. And the reason it won't work is because if they can't hear, they won't be able to know when folks are trying to page them so that they can do whatever those folks paging them need them to do. Maybe bring in boxes from the back room or go clean up some mess that got made or whatever it may be. And kind of putting on your skepticism hat, Maddie and I asked the question, well, wait a minute, isn't there a way that you can overcome that? I mean, how about a beeper or something that vibrates?
Yeah.
And as we thought through it, that it seemed that might make sense. But then the pushback was, well, the devices that we have that we thought we'd be able to use, it turns out they don't really vibrate.
Yeah.
And so we talked about, again, this is in the scale of this operation, this could make sense. Well, maybe you've got to spend a couple $100 on a cell phone, that vibrates. And the pushback was, and these are people I have enormous respect for. This is a great employer operating a great business that it's so in any event, but the pushback that we got was, well, we don't allow cell phones in the store.
Yeah, it's a violation of handbook policy. Employees aren't allowed to have cell phones on the floor.
And obviously, that is a policy that can be addressed if you have to accommodate someone, or at least I think it's the position I take in that is that, well, you can carve out an exception to that rule, and you can ensure that the individual doesn't use their cell phone for any purposes that we're not allowed to use cell phones for. They're not making calls. They get the cell phone from you at the beginning of the shift, and they're going to give it back to you at the end of the shift. And you shouldn't be too complicated to monitor that the usage is appropriate. So that's an instance where the employer can, first of all, that it is not an essential job function, in my view, to hear the page.
Right.
We can get around that, and an essential job function for that individual is to appropriately, let's say, store, stack, unload, load, whatever it is that they're doing. A second instance that I think helps to illustrate the point was We were recently working with a fairly large hospital system and a cardio surgical nurse. And that nurse suffered from a condition that at least episodically would require that she, as they describe it, break scrub, meaning leave the operating room such that she could attend to the symptoms that she encountered from time to time. And the hospital system argued that that's flat out impossible.
Yep.
And the argument came down to whether it is or whether it isn't impossible. That is, whether it is or is not an essential job function to remain scrubbed in and present for the entire duration of cardiac surgery.
Mhm.
And not surprisingly, the hospital system argued that patient safety is first, foremost, and maybe the end of the conversation. And the nurse argued very forcefully that patient safety is not in fact compromised if she episodically needs to break scrub for 5 minutes. So again, that kind of illustrates the question. I don't have a conclusion on that story because they resolved the dispute before a jury had to figure it out. But that's somewhat illustrative of the arguments that can arise from what is and what is not essential, such that I do or don't have to accommodate a disability.
And for the essential job functions, you know, a lot of times what's being examined is a job description. As you all know, job descriptions are generally drafted pretty broadly so that the company can basically say, well, anything I need you to do, that's what you need to do. That's part of your job description. But it's broken down a lot finer if you're in litigation or you're examining this as a disability discrimination to, you know, like Max pointed out, will this position be changed if we eliminate, you know, this line item? So, you know, just having an over-inclusive job description doesn't carry the day with regard to essential job functions.
Also, Maddie, you know, something else comes to mind on that surgical nurse question. This invokes one of the issues that we run into a lot. I run into a lot, and I imagine Maddie does in her practice, and that is the employer's consistent application of what the employer construes as essential job functions. In that case that we were referring to, there were instances where other people were provided the breaks that this individual claimed she might need. And consistency in so many areas of discrimination law is huge. If you have a policy and you're kind of making accommodations, I'm using the word loosely, for one person and you're not doing it for another person, that just raises big issues. And oftentimes it just comes down to it. It makes sense. We like this guy.
Right.
We really like this guy. We think he's terrific.
Mhm.
So if he needs to take a 5-minute break because he's having some issue that requires that, we're going to take care of him. Her, not so much.
Mhm.
And then, bam, she's in an expensive legal action.
So Max is going to kind of walk through the interactive process from point A to point B to point C, because we see so many employers run afoul of this process, and it's a unique process, again, to this type of discrimination. You know, race discrimination, this does not apply. Gender discrimination, this does not apply. So it's really important to hone in on this process and make sure that your company's policies and the way you interact with employees comports with your obligations.
We've talked about some of it, but the first commonsensical action is to talk to the employee to determine what their needs are. And that can, again, arise from the employee coming to the employer and saying, I need help, I'm struggling, or it may be the employer observes some issues, deficiency in performance, struggle to handle some aspect of what they do, in a sense that there may be something amiss here, there may be something that we can or should accommodate. And sometimes it's really obvious. If someone's got a severe limp, I mean, or if someone is clearly struggling with an issue that you can or reasonably should be able to discern, then that kind of kicks in the obligation to have that conversation or to initiate what we call the interactive process. And there's a lot of arguments that arise, and they can be expensive and aggravating arguments over whether that was in fact the case. Maddie, you've got something right now where they just didn't do the paperwork.
Yeah, that was, I'll go into this a little bit more when we get to our case studies, but yeah, you know, the interactive process can be informal. You know, if it's your practice to engage informally with the employees and have conversations, that's fine. But if you have policies and paperwork that you normally fill out during the interactive process, and when somebody requests an accommodation, then that's something you need to do consistently across the board. And I'll get into a little bit of a cautionary tale with regard to the failure to follow a company's own policies with regard to documentation.
The second piece that we've got up here is that we want to interact with the employees, or it may be necessary, often is, to interact with the employee's physician or psychiatrist or counselor or whatever. And generally, a commonsensical step, and you can either do it through the employee or with the employee's permission. You can just go directly to the care provider. You got to provide a job description that makes sense, and you got to require medical doc. You don't have to. You have the right as an employer to require medical documentation that actually demonstrates that this employee is disabled in such a way that they require accommodation. And the treating physician, I'll just say doctor, if that's the case, should provide pretty specifically the nature of the accommodation that's necessary. And it's, you know, this gets down to important details. You know, the doctor, the treating physician, or again, care provider, should get a pretty clear idea of what's at issue here. They should get a very clear job description. They should have an understanding of how much, or you should provide them with an understanding of what you need to know in terms of standing, sitting, interacting, lifting, as Maddie mentioned earlier, is oftentimes a big deal. Talking, whatever it may be. What are the break requirements going to be? What's the medication regimen? Not that I want to get into the specifics of what he takes and why he takes it, but you know, help me to understand how this is going to impact us so that we need to provide an accommodation. And if you don't buy it, get a second opinion. There, you know, it's just like in workers' compensation world. There are doctors, and not to impugn anybody's integrity, but there are professionals that sometimes plaintiff side lawyers will make use of to send folks to, and to kind of get confirmation of that which they're looking for. If you feel that's in play, or if you're just not comfortable, or you may just think, look, I think I'd like a second opinion, you can require one. The employer's got to pay for it, and you've got to reasonably schedule it, but you can require a second opinion. And by the way, I guess that comes under Part 3. You can require that disability, if it is in fact a disability, be recertified annually. And if there's reasonable doubt as to whether that disability is A, valid in the first place, or B, is still there, the employer can request at any time, again reasonably, for that to be recertified by a medical professional or by whoever the caretaker was or is.
All right, so I'm going to talk a little bit about some examples of accommodations that, you know, Max and I have seen that have come up in our practice and that we see pretty regularly. The first, and this is another unique nuance of the ADA. So there's an intersection between the ADA and the Family Medical Leave Act, the FMLA. If you're an organization with 50 or more employees and you meet other covered employer requirements under the FMLA, you're required to give 12 weeks of unpaid leave. And where the ADA comes in is what happens if somebody has exhausted their FMLA leave. They're dealing with a medical issue for themselves that may also be a disability under the ADA. And they've exhausted FMLA leave, and they come to you and say, well, you know, hey, I need an additional 30 days of leave. This is the day that I'm expected come back? Is that something that you're able to provide? You've already been out for, 3 months essentially, and you're frustrated. Maybe you don't want to give them additional leave. But if they're requesting an additional 30 days and it's an ADA qualifying condition, Max and I are going to tell you, give it to them.
Generally, I think that comes under the sort of the rubric of what is a reasonable accommodation. And generally, leave is construed as a reasonable accommodation. The question is how much? If you're Ford Motor Company, maybe it's 2 years.
Right.
But depending on the position too. But I have seen courts, at least in the Sixth Circuit, determine that leave in excess of a year may be a reasonable accommodation. But again, the question has to, come back to what burden does that impose on the employer such that they should sustain that burden. Sometimes people don't think through the alternatives too. I mean, can you use temporary contract workers to fill in while this individual takes their time off? At any rate, go ahead, man.
Or maybe even a work from home type arrangement is another accommodation that you can consider if that person is just not able to come to the shop.
That's a huge fight. People scrap about this all the time. Is physical attendance an essential function?
Right.
How important is it that you be there? And if COVID has changed anything, it's kind of changed the landscape with respect to how a lot of shops, how a lot of places view that. Now, if you're operating a machine, if you're, it kind of takes the mystery out of it. But if you're doing accounting work and you're handling payroll or whatever, there's a whole world of folks who are now working pretty effectively from their house.
But we always mention the Fmla when we're talking about the ADA because we see quite often employers come to us and say, well, this person's out of FMLA leave. I want them gone. You have to take a beat and recognize that if this isn't an ADA qualifying condition, there may be some additional concerns. So allowing employees to take bathroom breaks every 2 to 3 hours, that's actually the exact accommodation that we were dealing with that nursing issue that Max was talking about. That was the accommodation that the nurse sought, and it was a 3-year fight over it, essentially, hundreds of thousands of dollars in attorney's fees on both sides. So you just have to evaluate from your business's perspective, is this going to be a reasonable accommodation? And that was the fight that we were litigating. Allowing a cashier to sit on a stool rather than stand. The retailer that Max was talking about before that we represent, this is a regular accommodation that comes up, and that generally we recommend that, this is going to be reasonable. Providing a hearing impaired employee with a buzzer, again, that's another situation that Max and I just dealt with, where this retailer has significant financial assets such that getting them an additional buzzer or a cell phone is not going to be likely an undue burden.
By the way, though, in that case, there was some question as to whether that hearing impaired person, and I think they're maybe completely hearing impaired, so we used to say deaf, they can or cannot work a cash register.
Right.
And I think it was reasonable for the company to conclude probably can't work a cash register because they just have to be able to interact with customers.
Correct. So noise sensitivity is another kind of unique issue that we deal with quite often. It's often associated with certain types of anxiety. So moving an employee's workstation away from a loud copier, that's one that I dealt with, and we ended up recommending that employee give that accommodation to that employer, give that accommodation to the employee because they had open workstations away from the copier. Reassignment is another one that we deal with quite often, and again, just a word of caution there. If you are looking to actually change somebody's job and what they do every day as an accommodation, unless that's the accommodation that they're seeking and that's what they want and it works for you too, you're going to want to try to accommodate them in their current position. Part-time and full-time and scheduling changes. So are you able to put somebody who's full-time onto a part-time schedule? Again, if you're Ford Motor Company, you're probably going to be able to do that. If you're not, if you're a smaller shop and you don't have that many people, maybe you can accommodate that. And changing somebody's shift and schedule is another issue that we deal with, another accommodation request that we deal with quite frequently.
Also, moving from full-time to part-time implicates, the employee suffering loss of income. So
Correct.
that's something that, has to work for everybody.
Audio assistance, providing, I think that there is a case out there from Ford where somebody actually Ford had to hire somebody to assist somebody that was hearing impaired, and it was like having an assistant essentially.
Mm-hmm.
So again, Ford's a huge company. They had to hire somebody to help this individual deal with and overcome their inability to hear audio. But again, a mom and pop shop is not going to be required to do that. That's just going to be an undue burden. Emotional support animals, it's a huge topic. I'm a big dog lover, so I love dealing with this issue. But emotional support animals are generally not going to be an example of a reasonable accommodation, whereas a service animal may be an example of a reasonable accommodation, depending on health and safety issues. So generally, how a service animal is generally trained to provide a specific function. So a dog is helping an individual cross the street. A dog needs to be present to detect the early signs of a seizure, whereas an emotional support animal is just generally there for comfort. So that's generally not going to be an example of a reasonable accommodation. Max is going to talk about some of the more unreasonable accommodation requests that we've seen throughout the years, as well as what you do not have to do as an employer.
Yeah, so just starting with some fundamentals, generally you don't have to create a new position so that you can enable someone with a disability to sustain their employment. And I guess that makes sense because if they can't accomplish the essential job functions of the position they're in, generally, you don't have to create a new position. Again, you don't have to eliminate essential job functions. Not to say there won't be a scrap over what is, in fact, an essential job function. You don't have to give employees, as we talked about earlier, the accommodation of their choice. You don't have to provide an accommodation that creates an undue burden. Another one of those, it can be just an absolute den of ambiguity in terms of what's an undue burden. We don't think $120 to $250 phone is an undue burden for the client that we discussed earlier, but obviously for a typical business, forget mom and pop, just a typical business, it's and when I say that, I mean, let's say you have 200 employees. You're probably not going to be required to hire an interpreter, but that's really an important argument that we have to kind of take a clear view of in terms of what's the impact on this business, what constitutes an undue burden, such that this business is in fact compromised by undertaking that burden.
I think with undue burden too, that's one of the most litigated issues, I think, in disability discrimination context. And as a company, you have to decide, is this a fight I want to have, or is this something we can live with?
Yeah, exactly. And there may be kind of a reflexive response from a lot of employers saying, that's crazy, I can't do that.
Right.
Or that's just not something I'm willing or able to do. And that's fine, it may be. And if that's the hill we're going to litigate on, then, or that we're just going to say, no, we can't help you, and then that's where we need to be. But we at least need to think it through. You don't have to compromise the economic viability of the business. Here's an important one. You don't have to compromise safety. And that can arise in a number of instances. We talked about the nurse, but I mean, you don't have to let somebody who's demonstrated unstable behavior continue to be around folks that might have reason to fear that person. That's a big issue. Or very related, you do not have to accommodate misbehavior. We may, if we have time, talk about a kind of a case study type of scenario involving that. It's a frequently litigated issue as to, is this person's conduct conduct that we should put up with and or maybe refrain from termination because they've got a personality disorder. Generally, or it comes up a lot with substance abuse people.
Right.
Generally, the answer is no. We don't have to tolerate conduct that is that we've identified as misconduct that we won't put up with in our business.
That reminds me, just the other day, Max and I took a call. We had a client that said an employee kept calling off. She has a drinking problem, kept calling off, not because she was undergoing treatment, but because she was actually drunk and couldn't go to her shift.
Yeah,
and we counseled that that is not behavior that you have to tolerate.
Yeah, and again, and we don't make light of alcoholism.
Exactly.
And it is a recognized disability.
Yep.
And if someone, approaches the employer and says, I have, particular needs with respect to my sobriety, I have to go through rehabilitation,
Right.
I have meetings, I have, that comes within the scope of at least the question, can we reasonably accommodate it? Somebody comes in drunk, fire them. Or at least that you don't have to put up with that kind of misconduct.
Max, I have a question.
Yeah.
I'm sorry to interrupt. What is a, I'm just thinking about, excuse me, places that I've worked, and what is a reasonable amount of fear that an employee can have with another employee? So to me, that is so subjective. Someone might feel uncomfortable or feel that they're threatened by this person, in their own mind. And that, what's the criteria of saying, let's try to work this out versus maybe this person needs a psychiatric evaluation and shouldn't come back to work? Do you see what I mean? How do you determine?
Let me try and answer it with an anecdote if I can. And I wish I could just give you a, A plus B equals C type of an answer, but if an employee puts someone in reasonable fear for their safety,
Right.
Then that's kind of the watershed. But that's okay. So what do you mean by reasonable? So I went through a trial with an instance in which a fella approached very aggressively, angrily, an HR representative because he didn't feel that, ironically, he didn't feel that another disability was being properly accommodated. This guy absolutely had some psychiatric issues, or he had some personality disorder issues. But in that room, in the 20 minutes that he spent speaking with this woman, he put her in such fear that she was shaking, she was tearful. She undertook safety measures after that. She had her husband follow her home from work. She alerted law enforcement. She alerted ownership, and clearly she was shaken. Now the employee was terminated. The employee brought suit, and it was it was kind of bruising. And his position was, as you might predict, all he did was go in there, raise his voice a little bit because he was upset that the company was mistreating him, and he's got a right to make those complaints, and her fear wasn't reasonable. And that literally had to be decided by a jury who made the decision that her fear was reasonable and found for the employer in that case. So I just, again, during that conversation, I think it helps to illustrate the point. He was shaking, he raised his voice, he reached into his pockets and talked about hurting people, and she, had a fear that she didn't know what he had in his pockets. And again, his conduct was such that the jury found that she was reasonably afraid, and we're not going to tolerate that. We are not going to have our employees being afraid to come to work, afraid to drive home, or afraid in their own homes because this guy might know where they live. Again, the word being reasonable, and I wish I had, kind of a easy magic reference on that, but I think it's one of those things that reasonable people generally know when they see it. Is that responsive to what you're asking?
Yeah, thank you so much. And I'm sorry to say this time is, we are at 1:01. Maddie, were you about done with your slides or do you have more to present?
Yeah, I mean, we had a couple of case studies to talk about, but you know, we gave a lot of anecdotal stories today, so I think that we're good there. And then, you know, just reducing risk. If you have any questions on these ways to reduce risk, you know, policy wise, reporting wise, handbook wise, and just with a mindset toward accommodation, feel free to reach out to Max and I. We're happy to expand on ways that your business can reduce these risks.
Well,
Thank you for listening to us.
yeah, Maddie,
Yes,
thank
I
you.
appreciate it.
Thank you everyone for joining us today. And Maddie and Max, thank you so much for your excellent presentation. Anyone that's involved today, we encourage you to let us know any topics that you might be interested in us presenting to you in the future. We're here to help you solve whatever problems you might have. So maybe experts like Maddie and Max will be able to enlighten the topic for you. And as I mentioned earlier, we are recording these sessions and they will be available on our YouTube channel. Thank you, everyone. You all have a great evening.